to Legally Speaking with me, Tarun Nangia. Today we embark on our part 2 of our series on recent developments in the Prevention of Money Laundering Act. As we have seen in the past few months, courts have delivered various verdicts where they have, in a sense, made some observations with regards to attachment of assets, possession of assets, bail, and other provisions in the Prevention of Money Laundering Act. What those are, how will it impact cases in future, cases of arrests and bail, and how are the courts looking at the law? That is what we are going to discuss today. I have a very eminent lawyer joining me, familiar face on Legally Speaking. Good to see you, Senior Advocate Geeta Luthra. Thank you for your time.
Thank you for calling me.
At the outset, could you give me a 4-5 minute comment on how the courts have been looking at this law via various cases in the past 5-6 months?
So it's actually a defense lawyer's delight what the courts have been doing. At one time, we felt that it was like Abhimanyu's Chakravyuh, and we weren't going to break into it. And all the time there was this attempt to make forays, and every time they were being rebuffed, sometimes. And since all these special acts have the same features, which are the twin conditions, if there is a law to the benefit of an accused in one, it inures in another. So it was with a great sigh of relief, particularly to those accused who are languishing in jail, that they saw that judgment after judgment, there was some minor breakthrough, some tweak in the law, something which showed that civil liberties is still important and needs to be considered. So because of all that, the movement in the law, the judgments of the courts, whether the high courts and the Supreme Court, have given a sigh of relief to many litigants.
In the words of Justice V.R. Krishna here, bail is a right and jail is the exception. Do you think this is the rule that the Supreme Court has also upheld as with regards to PMLA cases?
So clearly, obviously not. The Supreme Court has recently again started saying that bail is the rule and jail is the exception, and this equally should apply to PMLA cases and to cases under NTPS, to cases under UAPA, to cases of SC/ST Act, all the cases which are special acts. The Supreme Court has of recent been saying that delay, for example, that these are constitutional courts. And just because these are special acts, the Constitution would allow the constitutional courts to actually intervene and grant bail where there is going to be a delay. So I think it was in 2022 that there was a judgment by Justice Bhatt's bench where they looked at it. Perhaps its name is Muslim, but Muslim versus State or some such name. But basically, that's what it said, that you cannot just look at, it was perhaps an NDPS case, and there had been huge delay, trial was being delayed. So question is, all these cases, the concept is as if today you're filing a ECIR and tomorrow you'll have a trial. But tomorrow you don't get a trial. You get one supplementary complaint, then you get a second supplementary complaint, then you get a third and a fourth. And frankly, the accused then is languishing, and the argument that is used is these are economic offenses, these are special offenses, these are crimes against with regard to public money against the state, and therefore are of great importance, and that's why an exception is carved out. Now the courts have started saying, no, bail continues to be the rule. And therefore, in terms of that judgment, Kurbak Singh CBI AIR 1980 Supreme Court, and we used to cite it when we started practice, the law has come back, Antil has reiterated it, and has in a special a paragraph talked about special acts, that special acts also need the same kind of protection. I think the best foray was made by Nikesh Tarachand, a judgment authored perhaps by Justice Nariman, which talked about the twin conditions and said you can't turn them on their head. You can't take away the right of liberty of an individual by saying that these are special acts and therefore bail is not the rule, but jail is the rule. So Nikesh Tarachand set the trend, but unfortunately, Section 45 once again amended. And this time trying to set at naught what Nikesh Tarachand has done. Now, review is pending with regard to these aspects because Vijay Madanlal then came, upheld most of the amendments, and again made the law in that sense, the interpretation of the law draconian from the ameliorated version or interpretation in Nikesh Tarachand. And Vijay Madanlal then brought in these changes, and the Supreme Court held against the petitioners. Now, fortunately, in a review, the court has said at least two of the grounds need to be examined, if not more. So I'm sure the argument, and it's been adjourned last 3 times, but the argument is going to be, is it just 2 grounds or is it at least 2 grounds? So there's going to be a big debate. One of the issues is Section 50. Section 50 PMLA, as well as in special acts, the statement that the accused makes, even while he is in custody, is considered to be admissible for purposes of looking at what the accused has said and whether people can be arrested as a result of that statement. Now, traditionally, the law, as the CRPC said, that if somebody is in custody, their statement is inadmissible. But Section 50 doesn't say that, and Section 50 is to the opposite effect. Now, very recently, Justice Gawai and Justice Vishwanathan, and I think the judgment actually should be applauded much more than it is been so far, in Prem Prakash versus Union of India, said that Section 50, the statements, if made during custody, are inadmissible. You know, the effect should be that half these cases would not be having a foundation to stand on if this is the true effect of Prem Prakash versus Union of India. So, according to me, sorry.
Please go ahead.
According to me, Prem Prakash has done a great deal for what should be a common law system. What is our judicial system all about? Our judicial system is about, or any criminal justice system based on common law, is a presumption of innocence of the accused. Now, here, the court, the mandate of the law seems to say, under the PMLA, that the court should believe that this person will not get out or has not committed the offense will not repeat this offense. What a threshold to meet! How can a court of law prejudge a trial and say not only a presumption this man did it, but he may not repeat it? Even his closest friend, even his heart won't know whether he will, if he is an accused who will be convicted, will repeat the offense. Now, for a court to be so clairvoyant and so able to predict, so that is why the courts have interpreted this and have said that just because there is the language used is this doesn't mean that you have to have a conviction of the innocence of the person. This is a prima facie stage. According to me, the prima facie stage has to be a stage, as Justice Nariman said, a stage of presumption of innocence. So if you are going by a state of presumption of innocence, then the court has no choice but to say that my presumption, because I am a common law country and I am a judge in a common law country, I believe that this person is innocent unless proved guilty. Therefore, I am holding this twin condition in favor. Whether he will repeat or not will be a matter of trial, because it is only the trial which will determine if he has actually committed even a first offense. So this is putting the cart before the horse or putting it upside down. So I think both those aspects, the courts can interpret very well. Now, two other interesting aspects I feel. One was Pankaj Bansal. I think Pankaj Bansal, the judgment came as a savior, because it says you have to give the grounds and the reasons for arrest. So reasons for arrest are different from grounds of arrest, and the grounds should be pertaining to that particular person. Now, one of the arguments, for example, made by Mr. Kejriwal's counsels was, look, if for 10 days, 10 times he wasn't arrested, and you didn't think, what was the new aspect that on the 11th time you thought he should be arrested? So there are these aspects which have come into play. Ultimately, no one can be allowed to languish. Justice Gawai, in a very recent judgment, said that you have to see what is the purpose of arrest, that a person, or what have you to ensure when you give bail, that the person will appear before the court when the date of trial is fixed, and he will not tamper with evidence. Now, in PMLA, tampering with the evidence is almost impossible, because a lot of it is documentary and there is a money trail, etc., which has already been captured. So question is, will he flee? Now, these are not people who can flee. They can't be fleeing because they have roots in society. Some of them are public men, some of them are businessmen. You're not seeing them flee, and you have to give enough surety, you have to give enough conditions that they cannot flee. That's all. But you can't arrest a person. And that's what Justice Ravinder Bhatt's judgment said. Now, in Senthil, one of the interesting issues I feel that Senthil Balaji, so it's very interesting how counsel can create a new proposition of law. And that proposition of law is, whether trial for the predicate offense has not started, could the trial for PMLA proceed? If a person is not accused in a predicate offense, can he be an accused in a PMLA offense? If a person is a witness in the predicate offense, if he is a protected witness in the predicate offense, Can he be an accused in the PMLA offense? These are interesting aspects. Some of them, the courts have given some views. Some views are contradictory. Punjab, Haryana, for example, have said that if you're not an accused in predicate, if you're a witness in predicate, you can't be. But it seems the Supreme Court is saying something to the contrary. In this case of Senthil Balaji, in fact, where Siddhartha and Mr. Rodgi are appearing, same issue has arisen whether the PMLA case can proceed if the predicate offense has not started and trial not being done. And Justice Oak and Justice Masih have reserved judgment. So we are getting a host of hope for the accused. Whether that hope fructifies or doesn't is another thing, but hope there is. Now, Manish Sisodia's bail. I mean, any discussion would be incomplete if we don't discuss Manish Sisodia bail, because I think that will be the single order which will give relief to many, many accused. The reason it will give relief to many accused is court said there are 493 witnesses, trial has to begin. We had not given bail, saying trial hasn't begun, but you're still at stage one. You are still ready to take off. Your flight's not taken off. So at least the accused deserves bail. And see, there are two aspects to a criminal case. And this is what Lord Denning also said in one of his books. He said, all of criminal law is about the right of the individual versus the right of the society or right of the public money, public justice. And how do you balance the two? And we have to ensure that the right of the individual cannot get plowed down by this fear psychosis that, look, this is public money, this is the right. You freeze the accounts, you have that right in civil proceedings, you do what you like, but you can't, for that reason, not give bail. There will be cases where you will actually feel genuinely that this person will escape. There will be cases where you may feel that the mandate of the law requires that bail should not be given forthwith. But a person can't be kept arrested just because of seriousness. Its seriousness cannot be, or the amount of money. Look, this involves 50 rupees, this involves 500 rupees, this involves 1,000 crores. Money is only a number insofar as a principle of law is concerned. Of course, it will shock your conscience. Somebody's cheated or somebody's taken away 1,000 crores. But ultimately, it's the principle of law, and we can't forget that. So coming back to the case of Manish Sisodia, to my mind, that case will actually probably let the floodgates open. So today, if we look at the figures, there are about 5 lakh people in jails. 4 lakh are under trials. 1 lakh are convicts. Approximately, I'm just saying, if about only 20% are convicts, you can't keep those under trials in and say that they can live to see another day and they can remain in all the time. Now, very, very recently, there is still another very interesting development. I think it was in Tarseem Lal. I also seem to believe that it's Justice Oak's judgment. I may be wrong. But it says that once it's Justice Oak's bench, it said that if an ECR has been done, if cognizance has been taken by the court, then after that, ED doesn't have the power to arrest. So it sort of compared it with all those cases where court of its own motion, the other judgment by Justice Lokur, that once you have not arrested an accused during the investigation, once court, you have filed the matter in court has taken cognizance, then it is only you will, if for special reasons you need to arrest, then you have to go back to the court.
Thank you. I need a small comment from you in this. Given the recent developments, do you think that the effect of twin conditions of Section 45 has been diluted to some effect?
So I believe that they've still not been really totally diluted, if you look at it. So till say 6 months ago or 3 months ago, when this host of judgments came, most people were going on the ground of infirm or woman and then looking for bail. Most people were looking at those grounds. Now, with this aspect which has come, I feel to some extent, it could be said that they've been diluted. Nikesh Tarachand diluted them. Now the courts are reading in words like, is there a need or necessity to arrest? Now this reading in, the reasons for arrest of this person, the fact that the language used with regard to arrest being that, is this person going to be held? So Vijay Nair also spoke about this. So I feel that I would be waiting for the review judgment really, which will come, which will, I believe, open the gates and possibly bring us back to Nikesh Tarachand. Possibly. I can't say it's necessarily going to happen. But till that happens, we can't be very sure. But that's what I believe.
Point very well taken. Thank you for sharing your views on the Prevention of Money Laundering Act. In our next show, we would discuss with you specific provisions related to attachment and possession of assets, as well as the twin conditions for bail that will be argued in the coming challenge to the review of the PMLA that is going to happen in the court in October, which is the review of Vijay Madan Lal Chaudhary. And in the run-up to that, we would like to discuss that with you. But that's it for now. Thank you so much for sharing your opinions and varied cases and the recent developments. It was indeed a pleasure to talk to you. And of course, I am sure the audience had a lot to take home. Thank you so very much.
Thank you.